can hear you just fine.
Oh, they can hear us. Okay.
We're turning you up, so I think we can hear you.
Hi, I'm Rachel Varghese. Welcome.
Hi, I'm Raquel Roberts and welcome. Can you hear me?
Yes, we can hear you. Thank you, Rachel and Rafael.
Great.
So item 3 on the agenda is recent articles of interest, and there was a lot of interest this quarter.
And one that came out on Monday that I could not attach is the follow-up to the announcement. So I'd be happy to give you an update on their decision once you get to that article.
Oh, very exciting. Well, and I think I made note, the Harris County one as well has some updates too. So let's kick it off with our neighbors to the north. So the Harris County, this was the article where there is an allegation that came internally. So from the former housing director, and he was, I say former because the same day that he made the allegations, he was since terminated from City of Houston. Comments, observations, thoughts?
Always. That's big city politics. In the article talked about how some people were former longtime law partners. I think how long ago that was would make a difference. Because our policy does have a window.
Was it right before he was elected? I think that's when he stopped.
So I think ours is 24 months.
I think too, this goes, in my opinion, goes a little bit into perception of conflict too. So how, whether or not you have an actual conflict of interest, the perception can be just as damaging as the actual conflict, whether or not it did exist within the time frame or not. The update that I saw is that the General Land Office cited them, had 5 formal findings against the city as an outcome of this allegation. So they conducted their own investigation into the budgetary process for housing, affordable housing, which was interesting that it doesn't follow procurement rules. So it was a city loophole in a way where they didn't have to go through the RFP, like fair process procedures that they have in place, that they were allowed to make decisions and go against recommendations on the point scoring system. I think that's where some of the challenges came up. Anybody have any other comments on this one? Since this is our neighbor.
You have an actual list of things that they're finding.
I didn't print the findings out, but the quote, and I have a rough quote because it was copied by hand. City of Houston does not have appropriate processes and necessary controls in place to meet the requirements of the housing. What is the word I'm thinking of? The budgetary process for
Allotment allocation.
allocation. Sorry. Thank you. So they did cite them formally, and the city's response was due on December 10th. So when I did a quick search for an update of an article, that I don't find the city's response just yet, but it was due on December 10th because the city informally, before they submitted their response, said everything's fine. And the unofficial quote was, "That's right, I'm the mayor. I made a decision that was contrary to our point system." So it'll be interesting to see their formal response and then if anything else comes out of it.
Yeah, I would have certainly thought it should go in front of the entire city council for vote, rather than just the mayor making the decision. It wasn't clear that was ever gonna happen.
No, it didn't sound like it was. And what was interesting too is that they had a point scoring system in place, and the decision that came out of the scoring system was not what was the final decision that the mayor made. I also don't think it sends a great message that this individual is no longer employed immediately thereafter the allegations. So I thought that, I mean, certainly, appears it could be retaliatory. But some of the quotes, sorry, I read on this one a lot. I was very excited because I've had experiences in this arena with our neighbors. So it was extra interesting to me. But the city unofficially stated that more information about the person who made the allegation would be forthcoming as to why they are no longer with the city. So it sounds very contentious, to say the least. But if it wasn't contentious, it is now.
Sounds like the city would be paying some settlement fee.
Sounds like at the very least, they have to amend their processes according to the general land office.
I think what you said about it being contentious, nobody touched on the fact that it was seniors housing versus the low-income housing. In that particular area, they didn't touch on it, nor did they expand on what the outcome is of building these homes. Yes, you could have built more low-income housing in the area, but they're so busy with who gets fired, who did what. They're not even talking about what the result would have been if the senior housing had been put into place. And I don't know if that's relevant or not. It's just a question.
And the sad part is, to your point, it was scrapped after all of this started coming up, bubbling up, that it was determined that it was a distraction and the project was scrapped altogether. So if it had, positive outcomes that were planned for it, those are no more, whatever the qualitative decision-making process was, we will never have insight into it other than an external investigation, because there was a decision, and what if it wasn't a conflict, whatever was the merit for it certainly has been scrapped.
One of the things that I tell people that makes our government in Sugar Land so good is that we term limit them and we don't pay them. And by taking the professional politicians out of our city to run it, you attract people who just want to run their city properly. They get a stipend, but they're not. Nobody on the city council or the mayor lives on the $652 that they get to cover their rubber chicken dinner trips every night. And that is something that works. If you want to be a professional politician, you can't come here and corrupt our city because we're not going to pay you to. So you're going to go somewhere else.
I think this also speaks to the issue of governance, right? Like how our charters are created. So like City of Sugar Land, it's not the strong mayoral system that the city of Houston has. So I don't know like what's within the scope of like what does require a full city council vote versus not, but with the mayor acting as CEO of the city of Houston, it points out a potential vulnerability that our city charter doesn't have because we're not set up that way.
It was a great observation. Any other comments regarding Houston and Harris County related to this article? Okay. So the next one I have is the rest of, or a lot of them were from the north. Not to say anything about that, but Plano City Council, is that the one? Let's see. This is where they were discussing refreshing my notes. Okay. So this is where they were discussing about repealing an ordinance that forces council members to withdraw from any vote where they may benefit $1,000 or more. And then the resident said that, that $1,000 was even too much, that $250 would have been more appropriate. So it was a discussion about that contribution level. So what is the update on this?
Well, the article that came out on Monday was they voted not to change the ordinance. But because the agenda has been posted by Friday, I was not able to amend it by adding it to this. We could talk about it.
That looked to me like that's a very restrictive ordinance and would be extremely hard to keep track of and follow all of the loopholes that could come in and out of it. I mean, if somebody that contributes $1,000 4 years later could be the neighbor of somebody that's up for a zoning change, and they may benefit. So how are you gonna keep track of that and know everything that may benefit or not benefit somebody that donated to you 4 years ago?
This came up during the task force. Did you want to talk about, or if you recall, it's been a few years, the thought process and the discussions that occurred, whether or not that should be included in the ordinance? You don't have to, if you don't.
I'm just, trying to think back.
We certainly have some wording around lawsuits. If somebody has a lawsuit against, you can't take the campaign contribution from them.
Yes. The task force had contemplated whether or not campaign contributions should also be, much like Plano's ordinance, the same as when you receive a gift.
Right.
That once you met a certain threshold, that you had to step down. And so there was quite a bit of discussion amongst the task force members related to whether or not that should be implemented. And until Andrew speaks up, I'll keep talking.
Okay, yeah, I thought we talked about, I remember talking about, there were already election laws that covered some stuff, the disclosure.
Right. One of the things y'all mentioned was the difficulty in keeping track, and how would we track it? How would you monitor it? And at what point would there be an issue where nobody could vote on something? And how do you, like you said, 4 years later, 5 years later, are we in how many campaign election forms, because they file them quarterly, are we going to go back and review for every agenda item, and how do you keep track of that?
The spirit of it's great, right? I mean, the spirit and theory of, we want to make sure that there are not direct conflicts and that everyone can vote independently, but the practicality of it seems a bit impossible.
You're not buying a vote.
Right.
And also our procurement process, our city council, mayor, they don't choose who gets awarded a contract. City employees do that, and city council merely gets to say yes or no. They go, all the companies that filed to put in Fountain, this is the one that we believe is best. Do you want to pay, do you want them to do it or not? So the city council doesn't have that authority. So, well, 6 companies, I want my cousin's neighbor to get it.
We actually disqualify a company if we find out they talked to a council member. So we remind council members, don't have these conversations, send them back to the purchasing office, or they will be disqualified from the process, because the ethics task force made it quite clear that appearances mean a lot.
Smell test.
Yep.
That's what keeps these as articles and not as investigations at this point,
For us.
That's what I'm saying for us,
Yeah.
that we're able to have these discussions, at an arm's length versus directly in our laps, which is much preferable.
Absolutely. And as I like to tell you, I bring these forward in case you see flaws or holes in our ordinance, so that as you look through these and you go, wow, if this was here, do we want to address it? And do we have the tools to address it? If we do, and if we don't, what should be changed? I would much rather have 1 million practice runs than a real run. And hopefully you never have a real run, but if you do, I hope the rules are in place to your satisfaction, that you feel like you can act adequately or appropriately evaluate and investigate, and institute whatever conclusion you deem appropriate.
My note on this one is if we ever did specifically, I wouldn't limit it to 4 years. I would just say to any previous campaign. And that way, you're in your 3rd term, I gave you money for your first term, I didn't give you anything in the second term, so it doesn't look like I've done anything for you, now you're running for your last term. I'm gonna get you to do what I want you to do before you're out of office.
It does shed a light on some of these other areas, though. I mean, even the volume of it. And this is probably just the tip of the iceberg. I'm sure there's other small towns and different things you can find, but it does, give me pause when I'm looking at this that, one, I'm appreciative that we're in a highly ethical city, but two, that this stuff does happen. And I don't recall which article it was, and we'll get to it, but there were some that had issues because they don't have the right controls in place. They don't have the right procedures. And the fact that, our next item is to continue the workshop that we're doing on the investigation procedures. I think that's important to have now before, something does or possibly arises, that we can at least rely on the fact that we've done our due diligence and decide and practicing and looking at these things objectively and critically, and then also have the procedures to support us. I think it's important because I think where a lot of these issues occur are cities that don't have this kind of structure. Any other comments on Plano?
It's a beautiful city.
Yes, I love it.
Wonderful.
I've lived it.
This is just more of a question to be reminded, like for our process, our code, do we have any language that specifies the time duration? I couldn't remember off the top. The time duration for when it's I guess when a member of city council can vote on an issue that may be perceived as a potential conflict due to a donation. Is there a time limit in which that's perceived as okay?
Yes, please.
At this point in time, we do not have any prohibitions on voting for an item in which you receive a campaign contribution. We do comply with state law and have conflicts of interest if it's a business or it's somebody that you work for or somebody that works for you, or if you receive a gift exceeding $100 from them. But we have nothing on campaign contributions, with the one exception of if you file a lawsuit, we have to return the campaign contribution. You cannot buy a settlement.
Okay, thank you.
Back to Dallas, that place must be.
So I said we were heading up north quite a bit today.
Anything beyond I-10, just don't trust it.
That's quite the corridor. It's really narrowed it down. I don't know that I agree with that.
New Orleans,
Memorial City's okay because it's on this side.
New Orleans is south of
Yeah.
I-10. So, careful.
As someone who frequents a ranch north of I-10.
Just don't trust the government.
Well, fair, okay. Fair. The Dallas Morning News, and there were, I feel like, were there two articles, or was it just a more complex issue? Nope, just the one. Nope.
They had
Okay.
the update as well, I think, Daddy.
Yes.
They have the ethics code that's been passed.
Oh, they have.
Oh, okay.
That's great, because there's people that keep going to jail.
There were a lot from Dallas for me to choose from. I had to narrow it down. But it's been a very, very busy quarter. I tried to pick the juiciest ones, but there were quite a few to choose.
I could not recall the number, but it said how many, there were a number of individuals that have been going
In jail.
Mhm. So, I mean, all to say that this is actually serious and important things that we're looking at and discussing, but,
And the irony, I don't know if you noticed, the irony is that the charity was to set up a place for incarcerated people.
yes.
You're
Yes.
building your own home, folks?
That's forward planning.
Or maybe very good planning.
What's funny is I didn't observe that irony, so I really appreciate you making. So some people think long-term, and that's, yeah, I mean, it's serious, and I was very surprised at how my perception of how rampant the corruption is and was. Now that they have their code of ethics, perhaps, it'll drive it different.
I believe we have 49 council members. No, that's New York, never mind, wrong city. I didn't give you that article. New York has 49.
Wow.
How do you vote on anything? How do you discuss anything?
They had some pretty good ethics questions.
Wow. So the quote that I starred, it was like, where there's a clear ethical problem here, a city council member is navigating economic development monies, bond monies, possible general fund money for a project. The Atlanta CEO said he would be the CEO of. So, I mean, the direct conflict of interest, I don't know how you get quite more direct than that. What's amazing to me, and I guess I work in compliance and ethics outside of this, and so I'm always astounded at individuals' ability to rationalize that things are okay, or I don't need to report this, or err on the side of conservative and report and say, hey, Meredith, is this okay? Should I be doing this? Although they did say he sought
The city attorney.
an opinion. Was that you, Raquel?
Oh, I might be confusing it with the next one in Dallas about consulting with the city attorney.
Yes.
That one was complex.
What came to mind on this one that I don't know, writing the policy that we thought about third-party payouts.
Yeah.
I want to look more into ours and see.
Didn't we have one last time that was similar in nature? I feel like we had a discussion around this
I
previously.
don't think it ever came up.
The
Because that's what this is
volunteer-
saying, is that he wasn't working for that company as a salaried employee. His salary would have been paid by another charitable organization.
It was just rerouted.
Right, but I don't know that our policy, I know we didn't discuss that as potential when we came up with the current policy.
Well, we have some language about receiving any benefit.
Mhm.
Right, but if that person has absolutely no financial contact with this company, but this is the company that's paying them,
But he's still receiving a personal benefit.
right, but our
From the
stuff
position.
specifically talks about they have to have a financial interest in the company that's getting the contract or doing the work or whatever it is. I don't think we have it yet.
A family member or something.
It depends on the language, right? If it says it's a personal benefit of an outcome versus like the direct party. I don't recall what the language states there.
Right, that's what I wanna see, because,
I can read you both definitions.
okay,
Financial benefit means any money, service, license, permit, contract, loan, travel, entertainment, hospitality, gratuity, or promise of any of these, or anything else of value to the official or an official's relative. The term does not include campaign contributions authorized by law. Personal benefit includes benefits other than those that are directly financially advantageous. These include non-financial benefits such as an enhanced reputation and success of one's career.
and the part about. When we talk about percentage of a company that they can.
Conflicts of interest. Under the conflicts of interest section, yes, sir. Next page. That'd be the rule of 10% of gross income.
Yeah, so fair market, $2,500, right? I could see this as being an area where someone could say, I think ABC Construction got the contract, they didn't pay me anything. I have no relation with them, nobody in my fifth degree, whatever that term is, has anything to do with them.
Sorry.
My money came from, I was given money by some other company, I'm not doing anything for that.
But he was still given money as a result.
Oh, I don't agree, I do agree that it's inappropriate and unethical, but does it violate,
The loophole.
like, is
I think it
that
does.
something that we should?
Personally, I think it's fine.
Okay.
I think it would warrant an investigation. Or like
Absolutely,
and by
but-
investigation, I mean a review
But if
of
we're
our
gonna-
language against, if somebody were to file a complaint on it.
If we're gonna be able to find somebody guilty of this, we have to not have a gray area where they can say, I didn't get anything from them. Money came from that person. I didn't do anything for them.
That person came on you for a get out of jail free card, what would you tell them?
Generally, if someone comes to me for get out of jail free card, I'm gonna say, well, it may, on this sort of situation, I say, well, it's a little bit gray, but remember the smell test. At the end of the day, I cannot definitively point to an actual violation, but this is just my interpretation. This is just a suggestion. At the end of the day, the rule of the board is what counts. So it's the panel of 7 that judges you and their interpretation of this. My interpretation is based on listening to the meetings, but do you want this read in church on Sunday morning? Do you want your grandmother to read this in the paper? Even if it's not a violation, how would you feel if your neighbor saw this? But I usually err on the side of, if you have to ask me, don't do it.
But this, our ethics.
It's always the safest
Policy is
route.
also an ever-changing document.
yeah.
And part of these sessions is to look at that.
So maybe we need to
Something-
close that loophole.
Right, and I think that's definitely something we should have at some point of discussion about this and see if we want to create any changes or language.
Because you can very easily make it benefit oriented and outcomes oriented versus like the direct party, right? So I mean, if you just word it in a little, like tweak the wording slightly where you may not receive a financial benefit of, a direct financial benefit of a vote or a bit, or, I'm fluttering over my words, but if you
Right.
receive the benefit and you make it oriented based on that versus like the direct company or the person that's providing it.
Like if you benefit in any way directly or indirectly through a third party, then it will be considered,
You might add some language that unless a normal citizen would also reap that benefit.
right.
Meredith, would we look at this in terms of a reasonable person's interpretation? Would we use that word? Because any reasonable person hearing that you're pushing for a project to go through so you can be the CEO. I mean, I'm just wondering if that word would make a difference.
I could see a situation, not necessarily in Shoreline, but, I want something rezoned. And I call a friend in another state and say, hey, do me a favor and slide $10,000 over to Diddy Mega Donuts and have them vote for my project. That should be a violation of our policy, and I don't think currently it is.
The current standard under the policy of the ordinance, the preponderance of the evidence. Which is a pretty high standard. If you'd like, I can put on your March meeting a workshop to talk about proposed amendments. I can put this on there, and anything else you may come up to email to me before your March meeting. And so that we can spend significant time on that as opposed to me sending you juicy articles.
Sure.
But it's probably a good time for review.
So,
Okay,
Definitely agree.
Madam Chair.
thanks.
Thank you. Good points.
Yeah.
All good points. It's exciting when everything is working the way it should and discussions go, in a direction where we might need to review current language and we might look at it and discuss it further and it might be fine how it is, but it definitely warrants a further look and review on how that language is written.
I would
And
always
in-
prefer to do that annually, if you don't mind.
Absolutely.
And in general, these policies the city has have a sunset or a review period anyway, whether it's 5 years or 10 years. So it would be potentially caught, but if the next people in this room years from now haven't seen this article, they might not think it either.
In the private sector, it's commonplace to review it annually or biannually, so every other year, to look at policies and procedure, your codes of ethics, things like that, so.
Do you want to continue with the articles or do you want to move on to the hearing procedures?
I think just in the interest of time, let's move to the hearing procedures, because I want to make sure, because we're so close, I feel like, to getting them to a place where we could finalize perhaps, or get it to a final draft, and then we would actually have formalized procedures in place.
That have to be through by city council.
Yes, but I'm saying like, where that's no longer a workshop item for us, we send it to the next step of the process. Yes. So did anybody have any other final comments, sorry, before we move on from articles? Okay. Item 4 is our workshop review of a discussion on ethics hearing procedures. Did everyone have a chance to review the updates and the modifications?
Yes.
I went ahead and redlined the changes that were made in the last 2 documents so that you will see them and you can let me know.
Okay.
And the red line did not show up. It was PDF. Would you like me to go over them?
Yes,
Yes.
please.
Okay. So in the previous meeting to this, I added the definition of good faith reliance, which I believe was language suggested by Anne. Hear nothing, move on.
Yes.
And then based on last meeting, I went through and verified which must be business days and which must be calendar days. So verification on 2A3, per the ordinance, it's business days.
A very simplistic question.
Absolutely.
On A2, where it says city secretary provides a copy to a person accused and to the city attorney. Is it a person accused or is it the person accused? I don't know. When I read it, I stumbled over it, so I didn't know. If it's,
I can make it whatever you want it to.
well, I didn't know if there was an appropriate article there or not. You have
B
the
sounds
legal-
better.
Shall or will?
I hate shall.
Was that Rachel or Raquel? I know one of you said something. I couldn't
It's
hear.
Rachel. I agree with you, Krista. The sounds better.
Okay. Sorry, I felt very minor to bring that up, but when I read it, I stumbled over it.
It is now the.
Okay.
What if it's several people? Should it be all persons?
You could put the person and a parenthesis the S. I didn't mean to open the door to that kind of
The
thing.
S is now added. I have the and the two with an S. 2 winners.
Just whistling along.
Fix it.
Yes, sir. Paragraph 4. It was 17. I have a typo. It should
Yeah.
be business days.
I got that one
It's
too.
business. 17 business days, as it now says. That's because the ordinance was 7 and 10, they added math together. Then paragraph B1 was added at the last, was discussed and added from 2 meetings ago.
I have a comment about that.
Yes, sir.
You say alternate members will participate when needed to ensure a quorum. And then the next one says that you want to have a full panel. Is the full panel required for a quorum, or are those two different?
Good question. So 7 members is a full panel,
Right.
4 is a quorum.
Okay,
So,
so I'm not sure, say you only have 5 members,
yes, sir.
does an alternate vote or not? I think it's worded both ways.
I would love assistance with wording that. What my goal was to say that at a minimum, there will be 5 people. But if we can pull alternates up there to make it 7, we would pull the alternates up. And that is our goal to have the 7, but we could still hold a meeting legally with 5 people. So I'm open.
I
to
think if you
suggestions.
just take the sentence out, alternate members will participate in discussion and vote when needed to ensure a quorum, if you just took that out.
Okay.
Because if there's not a quorum, you can't continue.
This is true, yes, sir. It's deleted now, yes.
Okay.
I struggled with that.
Can you repeat what's being removed? Is that B1, the sentence about the quorum?
Okay, does it look highlighted for you?
Yes? Oh.
This whole screen sharing thing, I'm not used to being the one who gets to do that. They don't usually give me control of the mouse. And so this is the sentence that has been deleted per Mr. Kellerman's request.
Okay, no, I'm not, I'm only seeing you guys.
Oh, how did I not? Rachel, are you seeing the screen?
Rachel, you are?
I can see it and it is highlighted.
Okay, well, something I just haven't done.
How did I do that?
No, you
Hit
are.
gallery
Gotta
view.
have her side because you are screen sharing.
Yeah.
Like
Okay.
it's, you have the
One of
indicator
us
on.
can see that.
Try gallery view, Raquel.
Okay. Okay, I'm there now. Thank you.
So I'm
We're all learning through this together. Sorry.
Raquel, are you
Yeah,
ready?
that is- yes, I'm good. So I see it highlighted and you answered my question. I
And
don't-
thank you for giving us that option to join through Zoom. I appreciate that.
Yes, agreed.
Yes, ma'am. As long as I have a quorum in person, we can do that. If I don't have a quorum in person, state law will not let me do that. So just letting everybody know.
Okay.
Because I've had to cancel 2 meetings with other boards because we didn't have enough in persons. So paragraph C, this is calendar days per the ordinance. And then under D, this language was added at the previous meeting. And I'm gonna have to scroll to the next page. Because this was all added. This line. And I covered it up. So this was also added. This was to discuss that you have the ability to request documents from the city secretary's office. And I think this is where I added, the next one's where I said you could carry to the next meeting. Any comments, changes, revisions? Are you okay with this language? Any better suggestions I'm open to?
Looks good.
Mhm.
This was added for your request, approval of the settlement agreement. This was added for the request for last meeting.
Yes.
Okay, and then I need to tell you what I did.
Before you go further,
Yes, ma'am.
the public hearing will be open to the public. That might be, you might not need both of those. So it might just be hearing is open to the public.
Actually, public hearing is a term of art,
Okay, good.
and so public hearing, yes.
Okay. When I read that, I was like, the public hearing will be open to the public. I was like,
It sounds kind of clunky, but
Okay.
for government,
It's a type of,
public hearing is what it's called. You have a workshop, you have a public hearing, you have
Okay.
an action item, a consent.
that's helpful.
So it does sound like I'm crazy there, but there is a method to that one.
Perfect.
I have a comment about that section.
Yes, sir.
You scroll down to
I'm sorry.
parties at the public hearing.
Yes,
You said that it can be accompanied by legal counsel or another advisor.
yes, sir.
And the next line, it said only legal counsel can help advise during the course of the hearing. Should that be legal counsel or the other advisor as well?
I had that question.
Okay, so that is on my suggested list of revisions.
Okay.
Because when I went through the code and was writing it, I went, well, that makes no sense. And so it actually, under section 2-100. So 2-100, the public hearing states that only the respondent. Okay, so under, I'm sorry, 2-100C, the accused official, former official, or candidate has the right to attend the hearing, the right to make a statement, the right to present witnesses, and the right to be accompanied by legal counsel or another advisor. Only legal counsel to the official, former official, or candidate charged with the complaint may advise that person during the course of hearing. So I'm not sure why they would have a right to have another advisor if they can't advise them during the
Yeah.
meeting.
Yeah.
Moral support.
And then in the very next paragraph D, the complainant has the right to attend the hearing, the right to make a statement, and the right to be accompanied by legal counsel or another advisor. And there was a sentence I've lost where it says only, yeah, it needs work, but we need to make the revisions in the code of ordinance to make it make sense.
Okay,
So can we get that on the list for March?
yes, that would be great.
Wonderful.
And then we'll make it consistent.
That would be great. Write that down so I don't forget. Okay. Anything, or I can keep going?
Does it, witnesses may not be presented by the complainant except with permission.
That is also
Yeah,
in here, the code of ordinances. If you want me to change that, we can put that on March as well.
can we discuss it? What, we just put it, like, just put it for a discussion?
We're not
maybe?
making actual changes.
Yeah.
Any changes you
Has to be approved.
suggest, you will then workshop with city council with your help. It'll be a joint board, because these are your ideas. This is your board. I can't do this for you, but I'll sit there and hold your hands.
But the review board can request a witness, right?
Yes, sir.
Yes. That's in
So I don't
here.
know that necessarily needs to be changed. As long as that there's some way of requiring or requesting the witness to be present.
Well, what I didn't understand from a layman perspective, I didn't understand why one said upon board permission, but the other one did not. And I know it was, I assumed that it was because one was like the complainant versus the respondent, but I just didn't know if there was a legal reason as to why it was there.
Not a legal reason. When this was drafted with the task force, it was drafted, and I'm not gonna own all of it, but a lot of these mistakes are most likely mine for not catching them. But we did not think about putting the procedures in place at the time. And so it made sense as we were writing it, but then now that we're at the point of how does this work, I am seeing holes.
Okay.
And it's like, well, how's that gonna work? And we wanted to be flexible enough so that we could do it when we needed to.
When we were writing this, our focus was, we wanted a document that would be accepted and passed. We were not at all focused on, once these rules are in place, how are we gonna execute them? Because we didn't even know that our work was going to be accepted. But in court, providing a witness to something, it's the court that issues me the subpoena to show up, right?
Based on the
And
request of the
not the
parties,
defendant or.
based on the request of the parties. So if I'm having a case and I need all of you to be witnesses, I go to the court with the draft and say, I would like to subpoena these people. And it's on their form and they stamp it, the court clerk stamps it, and then I have to pay money for a constable or a process server to come out and give you the piece of paper says, guess what? You get to go party with me in the court on this date. You two, come on. So I'm not actually doing the subpoena, but I got to do the subpoena.
Okay, so if the review board can request that person be there, then. it doesn't have to.
So I didn't understand, I didn't hear what you
If the
said.
review, if the ethics can request a witness to be there, then the complainant doesn't have to. Because they're presenting the evidence to us, they're not presenting evidence on their own behalf.
But we could not request someone that they feel should be present, right?
Yes, but, and this is gonna get to the next. We get a little bit farther down on the hearing process where I made a bunch of changes. On their general hearing procedures, and let's go down to there. So I rewrote most of this from our last discussion because I had some light bulb moments where before it sounded like you were just a jury sitting back there watching the DA and the defense attorney go to work. And the more I thought about it and I went back and read the code of ordinances, I realized, wait a minute, this is not a jury trial, this is a judge trial, there's just 7 judges. And so you're running the show. You decide which witnesses to go, you decide what evidence comes in. So the person files the complaint and they give you the information, but it's not necessarily them up there prosecuting the case. And so I had to rewrite it so that you were the judges, you were running the show, and you're saying, okay, this is the charge, we've done our investigation, this is what's laid out. In fact, it's almost like you're the DA. The charges have been brought to you, and now you're determining whether or not this person, the person who the complaint is filed against, the respondent, can defend themselves to those allegations, as opposed to the complainant having the burden of proof. I was concerned that if we shifted it that way, it would chill any citizen's desire to come forward or it'd make them afraid to actually file a complaint if we put them in the role of prosecutor. So
Which is why you don't have the complainant making a statement in the hearing, I guess.
not unless they want to, or unless you ask them to, because once they've filed the complaint
Right.
and they've given you sufficient information, their responsibilities are pretty much done. I didn't want to put such a
The burden
high
on-
burden.
They have to swear to it and everything. You know, I mean, there are, I don't want to say barriers, but there are, you have to be serious about coming forward with an allegation. You sign and swear to it. So, I mean, that is already there, but we don't want to add a layer of,
I didn't want to.
and
Their
you have to get in front and
responsibility
to press.
and their burden
Right.
to prove the case.
Mhm.
I thought that was too high of a bar and it would chill anybody's ability to come forward. Because you are appointed, I was hoping that you had enough strength that you could actually be in the position to go, okay, we will take the facts, we'll be the fact finders, this is the information, now defend yourself.
It's not like Matlock, where a surprise witness that's gonna pop up.
Well,
In theory, we should have spoken to this witness
but we
during our investigation. Not necessarily. But,
The investigation is public, right?
right, but it's not gonna be like we're sitting there going, no.
But we do
It's at
tell
this
the
meeting, we
complainant,
decide whether they're guilty or not. Without knowing.
we do tell the complainant they have a right to attend and a right to make a statement. So I think we should have somewhere in there, if the complainant chooses, this is where they make the statement. For the procedures. Now, maybe that's included under number 4, but would that be before the respondent makes an opening statement? I don't know.
I can see that happening at the verdict portion, like the victim impact statement happens in criminal cases where Ajib unfounded, not guilty. Complainant really has nothing to say, but if the person is found to have done something wrong, at that point, they wants to make a statement to the guilty party, they can.
I will default to a resident attorney on where it makes sense, but logically to me, I almost feel like if we're going to include that, chair reads the complaint and opens it up, I would almost feel like they would open it up with a statement, like this is in their word, if they want so choose, in their words, this is why I brought this forward and what I witnessed.
I was thinking I could add it between 3 and 4, that the respondent makes a brief opening statement. And then should the complainant wish, or something like that nature, with permission of the board, the complainant may make a statement, blah, blah, blah. And
I actually thought it would go between 2 and 3.
Yeah,
2 and 3, I can, this is your document.
I
would
agree
put
with
it
that,
between 2
just
and
because
3.
I feel like then it'll already be contentious, but I feel like it complaint then response.
Respondents get to respond.
Right, versus they respond and then it's almost like a rebuttal. Exactly.
But you can add the wording, should they choose, maybe, so we're not forcing them to get up there.
Yeah, and under the 1.2, the above it says the complainant has a right to attend the hearing, the right to make a statement. So, but I guess they can choose not to.
I've got that as the new number 3. Make that pretty and have it out to you on the next agenda. What else you got for me to put in this section? And are you okay with my revising to the point that you now are in charge and it burden's not on the complainant? Because that's how it was before, it was a trial, and I thought, wait, we're never gonna get a complaint if I do this. Not that I want a complaint, but I just think that.
You want to make sure we're open to hearing it, and that.
Don't intimidate anybody.
The accused will always have the information as to who the complainant is. The complainant, I don't know, do they have to be? Like you have the right to know who your accuser is.
Signed and sworn, yes.
Right. So once they sign and swear it, and you go through the process, whoever's the allegations against, they know who it came from. Do you require the complainant to be there necessarily?
It
I
doesn't say
don't,
that.
I mean,
I don't know
could see
that I
someone like
would.
that. Look, I've done everything I needed to do to get this taken care of. I don't need to look the person in the eye.
Yeah, it doesn't say it's
Right.
required.
Would you like it to say it's required?
No,
No.
I don't want to put somebody in that situation if they've already done everything they need.
I guess if it's an unusual circumstances, we could subpoena.
Yes, sir.
If we
Yes,
wanted.
if we needed,
Yeah.
absolutely, that's a great point. If we needed the witness testimony, that's an excellent point.
Self, and your person doesn't have to go through.
Rachel or Raquel, do you have anything? You're being very quiet.
Just thinking, was it decided, I wasn't clear though on what was decided to address the complainant. And whether or not we're giving them the option of making a statement.
Yes, ma'am. I'm going to add a provision between paragraph or section 2 and section 3 to the effect that should they choose, the complainant may make a statement. I'm going to play with the language a little bit, but that's where the next draft you see will have it included.
Okay, I didn't hear that. Thank you.
Yes, ma'am. Go on.
Yes. Yep. Any other commentary around that section?
The next change I made, and I don't know what the change was, but it's highlighted on my computer. For E1, after the respondent summation, the IERB will deliberate on the complaint. I didn't write down what change I made, I'm sorry. Oh, I know what it was, okay. On that one, and down here on 5, I changed where it had independent ethics review board to the abbreviation of IERB, just to be consistent. Was the change I made there. And that was the last change.
Is there any feedback on anything to the end?
And the deliberation on the complaint, that is to be done publicly, correct?
Yes, ma'am.
Okay.
Oh, actually, I think you do have the right to do that in a closed session. That was I do recall a bunch of discussion with city council on that.
So if that's an option, then we could modify the language to indicate that.
Okay, so under section 2-99H, the Independent Ethics Review Board may conduct hearings and other proceedings on a complaint in closed executive session if permitted by state law, but any decision must be rendered during an open public meeting. So yes, you do have the ability, should you so choose, to go into executive session, shut the door, if you wanted to deliberate without the public eye. But any decision must be announced publicly.
Okay.
So do you think we should incorporate that language?
Yeah.
I mean, it's just kind of clarifying what's already been said, but
I can certainly add that. So that would be after 2, before 3, before you take the roll call vote.
or after 1. We might, before making the decision. I don't know.
And whether or not that's done publicly versus executive session, does that require a vote, or it could be just consensus at the time?
A consensus that you're going to move into executive session.
Mm-hmm.
Your agenda would most likely say on their item, whatever, at this, a deliberation amongst the board members, maybe an open or public session. And then the chair would ask, and then someone would say, I recommend this, and the person goes, I concur, all in favor. And so it'd be kind of, it would not be necessarily a roll call vote, but it would have to be a consensus.
Okay.
With all due respect, I would like to put it between 2 and 3, because typically if you're in a trial, you give the jury their charge, then they go into the back room. And so just because that's how my brain works.
Okay.
But I do like having it called out. I feel like it can mitigate any questions or concerns when, if and when that were to.
Yeah, because it is kind of implied, it's good, it's part of the open hearing, I mean, we can read that.
Yes, and I actually had to read the code to make sure,
Right,
because
right.
There you go.
I couldn't remember. So excellent question. What else you got?
I had some, I guess, questions or comments about the name clearing proceedings.
Perfect, yes, sir.
And it said when an informal allegation of a potential violation has been made. And then it asked for the name, the filer's name. if it's an informal violation, perhaps we may not have all of those things.
Well, do we have anything that's informal? Because if it's signed and sworn,
Yeah, that's what we talked about before. We didn't want to search out anonymous stuff, you know, if they weren't willing to put their name and swear it.
No, but this is the person who's accused,
Yeah.
says, hey, I've been accused of this, I want to clear my name.
Oh,
But, and so it's, but it says an informal allegation. Now, what is an informal allegation versus a formal allegation?
So informal allegation is actually what was in the code that was adopted.
Okay.
And I think what they had in mind is a number of years ago, I believe it was Mayor Wallace, but don't quote me. No, it was Russell Jones. A comment was made, something happened in the paper, and he wanted to have the board say, home free, you didn't make this mistake. So there was no complaint made, but there was an allegation in the paper, and there was an op-ed or something. And he was very, very much of the opinion that he needed his name cleared by the board. But then we went through the whole routine and explained to him that the board is city council. And do you really want to do this? Sometimes if you ignore the paper, it goes away, as opposed to let's have a public hearing and have everybody vote on it. Do you really want to make this bigger than it is? And I don't recall, no, we never convened the board. They were in the midst of adopting procedures, and then Councilmember Jones said, forget it, I'm not gonna play.
Okay,
So that was the informal that I believe we were trying to address. I can change the language, I can make recommendations, and we can talk about it in your March workshop. You would like to change the language up?
and my comment is, then it says, if you're gonna file this, you gotta include all of these 7 items that makes it more like a formal allegation. I mean, he may not know the name of the filer's name, it's just a rumor in the paper.
And I think it would be the published, it'd be like the Star, the Chronicle, and that would be
Sure.
the source of the rumor, not, hey, next door said this, and it was, you know, the greenhouse was the person's name, and it's really hard to say, well, the greenhouse says,
Okay,
but we can certainly look at that. And these are the list I have. If you wouldn't mind sending me a list of any comments you'd like, I would look at other cities and bring back any ordinance language they have to assist with our discussions. So that you have examples of how other cities have addressed those, as opposed to us saying, hey, you might want to change this.
Great.
And then me trying to make up something on the spot.
but you're so good at that.
You flatter me. So if you don't mind, the possible changes to discuss at your Mark's workshop would be looking at third-party payoffs, like a benefit or an outcome benefit. Parties at a public hearing, advisory language. And I have can a complainant request a witness? And informal allegations, name clearing. So I will look for samples from
In
other.
the
Yes, ma'am.
executive session edition.
Oh, I've already written
Oh,
the
you've already
changes
put
to
it
the
in there.
procedures.
Okay.
These were changes to the code.
Got it.
On the changes to the procedures, I have added.
Meredith, your changes
Yes,
are
ma'am.
actually very good. And that's not a general very good. I was reading it again and again. I realized one of the other articles, the review board was just that. It was a review board, but they didn't have the ability to make any changes or anything like that. The way it's been rewritten for us, it allows us to not only review it, but ask the person who has a complaint against them to come up and say, you know, A, B, C, here's a sequence of things that you must provide. And it gives a little bit more, I don't know if the correct word is power, but it gives a little bit more responsibility to the review board. So your changes are actually very helpful.
Thank you. My changes to the procedure would be, and I'm gonna have to play the language a little bit, but I added, should they so choose, the complainant may make a statement during the hearing process. That the IERB may deliberate in closed or open session, but the vote must occur in public. And then I made the other changes, but those were the 2 significant changes. I fixed my typos on days in business. And I added the and the S to the accused. So,
I think we have our,
Madam Chair, if I understand, the next meeting, I will bring these revisions with the language. I will bring samples of ordinances I can find from other places referencing these type of things being adopted into a code of ordinance of ethics. And anything that you email me by the end of February, because the meeting is in March, email me directly. Do not email anybody else because we have a quorum issue if you do that. I don't need to have that on top of everything else. But if you will email me any suggested revisions you would like to discuss, like I said, I will look for other ordinances in other cities that have those in there. And maybe even if I have some spare time, find a couple of newspaper articles that would address that specific topic. That may be wishful thinking, but if I can, I will try to provide that to assist you with your discussion. That being said, it sounds kind of like a lengthy meeting. Would you be open to an hour-and-a-half meeting? Or would you like to stick to an hour?
Rather get it done in one meeting.
Yeah.
Rachel, Raquel, how do you feel about that?
Yeah, I'm open to an hour and a half.
Me too.
We will, Brandon will send out his survey that he does and try to find a good time period that we could block an hour and a half. I would agree that it'd be better to do it all in one instead of having to
Yes.
restart.
Hopefully we can have our finalized recommendations of our procedures at that point. To supplement the code changes at the end of that session. So that would be,
And as we have been doing, all these documents, including any articles I can find, will be uploaded with the agenda. And so I believe the city secretary emails you either the link or the documents yourself. Uh-oh, no.
no, yes, so I don't know from a city procedure perspective, so please educate me on this. But if we're going to be looking at other city ordinances or codes rather, in comparison to our code, is there a way we could get that more than like a couple days in advance? I don't know how that works with how you post it publicly and all of that, but just to allow for more time for digestion.
I can email it to you. I will email it to myself and blind copy everybody so that somebody doesn't inadvertently reply all. And I'm a big open meetings act person. So a week, 2 weeks.
A week?
Rachel, Raquel would be a week, no, a week in advance fee.
A week is great. Thank you.
That's fine, that'll work.
Thank you.
So I will try to get it to you 1 week prior to posting.
They tend to be lengthier documents, so.
I understand, yes, sir. But I am a perfectionist and unfortunately I revise and I revise and I revise. And the city secretary is going, okay, you've got 10 minutes till you post. I'm like, okay, so that's what I do. So, yes, I can meet you deadline.
Okay. So we have our plan for next meeting. In the interest of time, it's almost 4:15. Do I have a motion to
I
adjourn?
make a motion to adjourn this wonderful meeting. And everyone have a wonderful Christmas.
I second that.
All right.
It's a great motion.
second.
Second, all in favor?
Aye.
Meeting adjourned. Thank you so much.
Thank you.
Have a Merry Christmas.
Same to you.